going to break the law on this day. It never happens that way. You have to do it with circumstantial evidence, or if you're Congress and you realize how difficult it is to prove specific intent, you will formulate a statute that allows for gross negligence. My time is out, but this is really important. You mentioned there's no precedent for criminal prosecution. My fear is there still isn't. There's nothing to keep a future Secretary of State or President from this exact same email scheme or their staff. And my real fear is this. It's what the chairman touched upon. This double-track justice system that is rightly or wrongly perceived in this country. That if you are a private in the Army and you email yourself classified information, you will be kicked out. But if you are Hillary Clinton and you seek a promotion to Commander-in-Chief, you will not be. So what I hope you can do today is help the average person, the reasonable person you made reference to, the reasonable person understand why she appears to be treated differently than the rest of us would be. With that, I would yield back.
We'll now recognize the gentlewoman from New York, Ms. Maloney.
Director, thank you for your years of public service. You have distinguished yourself as the Assistant U.S. Attorney for both the Southern District of New York and the Eastern District of Virginia. That's why you were appointed by President Bush to be the Deputy Attorney General at the Department of Justice, and why President Obama appointed you as the Director of the FBI in 2013. Despite your impeccable reputation for independence and integrity, Republicans have turned on you with a vengeance immediately after you announced your recommendation not to pursue criminal charges against Secretary Clinton. Let me give you some examples. Representative Turner said, and I quote, "The investigation by the FBI is steeped in political bias," end quote. Was your investigation steeped in political bias, yes or no?
No, it was steeped in no kind of bias.
Thank you. The Speaker of the House, Paul Ryan, was even more critical. He accused you of not applying the law equally. He said your recommendation shows, and I quote, "The Clintons are living above the law. They're being held to a different set of standards. That is clearly what this looks like," end quote. How do you respond to his accusations that you held the Clintons to a different set of standards than anyone else? Did you hold them to a different standard or the same standard?
It's just not accurate. We try very hard to apply the same standard whether you're rich or poor, white or black, old or young, famous or not known at all. I just hope folks will take the time to understand the other cases, because there's a lot of confusion out there about what the facts were of the other cases that I understand lead good people, reasonable people to have questions.
Senator Cruz also criticized you. He said that there are, and I quote, "serious concerns about the integrity of Director Comey's decision." He stated that you, quote, "you had rewritten a clearly worded federal criminal statute." Did you rewrite the law in any way or rewrite any statute?
No.
Now, I truly hesitate to mention the next one. But Donald Trump took these conspiracy theories to a totally new level. He said, and I quote, "It was no accident that charges were recommended against Hillary the exact same day as President Obama campaigned with her for the first time." So did you plan the timing of your announcement to help Secretary Clinton's campaign event on Tuesday?
No. Timing was entirely my own. Nobody knew I was going to do it, including the press. I'm very proud of the way the FBI, nobody leaked that. We didn't coordinate it, didn't tell. Just not a consideration.
Mr. Trump also claimed that Secretary Clinton bribed the Attorney General with an extension of her job. And I guess this somehow affected your decision. I know it's a ridiculous question, but I have to ask it. Did you make your decision because of some kind of bribe to the Attorney General?
No.
I tell you, are you surprised, as I am, by the intensity of the attacks from the GOP on you after having made a decision, a thoughtful decision, an independent decision with the professional staff of the FBI.
I'm not surprised by the intense interest and debate. I predicted it. I think it's important that we talk about these things. They inevitably become focused on individual people. That's okay. We'll just continue to have the conversation.
I believe that what we're seeing today is that if the GOP does not like the results of an investigation or how it turns out, and we saw they originally were lauding you, the minute you made your announcement, they're now attacking you, the same people. And now I predict they'll be calling for more hearings, more investigations, all at the expense of the taxpayer. And they do this instead of working on what the American people really care about. They want Congress to focus on jobs, the environment, homeland security, the security of our nation, affordable child care, affordable college educations, and an economy that works and helps all people. I thank you for performing your job with distinction and the long history of your whole profession of integrity and independence. And thank you very much. My time has expired.
Thank the gentlewoman. We'll now recognize the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Thank you, Mr. Chairman. Director, thank you for being with us. On Tuesday, you said any reasonable person in Secretary Clinton's position should have known that an unclassified system was no place for these conversations. You said on Tuesday some of her emails bore classified markings, and you also said on Tuesday there were potential violations of the appropriate statutes. Now, I know a bunch of prosecutors back home would look at that fact pattern, look at that evidence. You even referenced it in your opening statement. Some of your friends in the prosecution business have been on TV saying they'd have looked at that same evidence and they would have taken it to a grand jury. But on Tuesday you said, and today in your opening statement you said, no reasonable prosecutor would bring such a case. And then in your statement Tuesday you cite factors that helped you make that decision and make that statement. And one of the factors you said was consider the context of a person's actions. Now, typically when I hear context in the course of a criminal investigation, it's from the defense side, not the prosecution side. It's at the end of the case after there's been a trial and a guilty verdict, and it's during the sentencing phase, mitigating circumstances. That's the context we typically think about, but you said it on the front end. You said consider the context of the person's actions, and so I'm curious, what does consider the context mean? Because a lot of Americans are thinking just what the chairman talked about in his opening statement, that there are two standards. One for we the people and one for the politically connected. A lot of folks I get the privilege of representing back in Ohio think that when you said consider the context, they think that's what Mr. Gowdy just talked about. The fact that she's former First Lady, former Secretary of State, former Senator, major party's nominee for the highest office in the land. And oh, by the way, her husband just met with the individual you work with at an airport in Arizona 5 days ago. So you said none of that influenced your decision, but tell us what consider the context means.
Yeah, thank you, Mr. Jordan. What I was trying to capture is the fact that the exercise of prosecutorial discretion is always a judgment call. It is in every single case. And among the things you consider are, what was this person's background? What was the circumstances of the offense? Were they drunk? Were they inflamed by passion? Was it somebody who had a sufficient level of education and training and experience that we can infer certain things from that? To consider the entire circumstances of the person's offense conduct and background. I did not mean to consider political context or things
the
like
entire circumstances, and Mr. Gowdy just talked about this scheme. Remember what she did, right? She sets up this unique server arrangement. She alone controls it. On that server, on that email system are her personal emails, her work-related emails, Clinton Foundation information, and now we know classified information. This gets discovered. We find out this arrangement exists. Then what happens? Her lawyers, her legal team decides which ones we get and which ones they get to keep. They made the sort on the front end. And then we find out the ones that they kept and didn't give to us, didn't give to the American people, didn't give to Congress, the ones they kept, they destroyed them. And you don't have to take my word, I'll take what you said on Tuesday. They deleted all emails that they did not return to the State Department, and the lawyers cleaned their devices in such a way as to preclude complete forensic recovery. Now that sounds like a fancy way of saying they hid the evidence, right? And you just told Mr. Gowdy thousands of emails fell into those categories. Now, that seems to me to provide some context to what took place here. Did Secretary Clinton's legal team, let me ask it this way. Did Secretary Clinton know her legal team deleted those emails that they kept from us?
I don't believe so.
Did Secretary Clinton approve those emails being deleted?
I don't think there was any specific instruction or conversation between the secretary and her lawyers about that.
Did you ask that question?
Yes.
Did Secretary Clinton know that her lawyers cleaned devices in such a way as to preclude complete forensic recovery?
I don't believe that she did.
Did you ask that question?
Yes.
Do you see how someone could view the context of what she did? Set up a private system. She alone controlled it. She kept everything on it. We now know from Miss Abedin's deposition that they did it for that very reason, so no one could see what was there, based on the deposition Miss Abedin gave. And then when they got caught, they deleted what they had, and they scrubbed their devices. Is that part of the context in evaluating this decision?
Sure. And understand what inferences can be drawn from that collection of facts, of course.
All right. Mr. Chairman, I yield back.
Thank the gentleman. Now recognize the gentlewoman from the District of Columbia, Ms. Norton, 5 minutes.
Thank you, Mr. Chairman. Director Comey, I appreciate your conduct of this investigation in a nonpartisan way, in keeping with the sterling reputation which has led presidents of both parties to appoint you to highly placed law enforcement positions in our federal government. I want to say for the record that this hearing, where you call the prosecutor and Mr. Comey stands in the place of the prosecutor, because the Attorney General has accepted entirely the FBI's recommendations, where you call the prosecutor to give account for the decision to prosecute or not a particular individual raises serious questions of separation of powers, and particularly when you're questioning the prosecutor's decision with respect to the decision to prosecute or not a particular individual, it raises serious bill of attainder constitutional questions. These hearings are so often accusatory that they yield no guidance as to how to conduct business in the future. And that's the way it looks. It looks as though that is how this hearing is going. Now, of course, now everyone understands in the abstract why it is important for security reasons to use official government mail or email rather than private email if security matters are involved. And that's a very broad, wide proposition. Now, there are no rules, so far as I know, requiring members of Congress to use how they use their official email accounts, whether involving security or not. The chairman of this committee lists his personal account, for example, on his business card. No one says that's wrong. I don't know if it's wrong or right, because there's no guidance. Federal agency employees, members of Congress, often have secure information, or at least sensitive information that shouldn't be made public. Some of our members are on the Intelligence Committee or the Defense Committee or even this committee and may have such matters. Some of these matters may concern national security issues. And I don't know, something as sensitive as the itinerary, as if you're going on a Codell, as to the route you are taking and where you will be. All of that could be on people's personal emails. Of course, this is legislative branch, and I spoke of separation of powers. I'm not indicating that there should be a government-wide sense that is ordained from on high, but there ought to be rules that everybody understands about, especially after the Clinton episode, about the use of personal email. So I'd like your insight for guidance as far as other federal employees are concerned, or even members of Congress and their staff, because I think we could learn from this episode. So strictly from a security standpoint, do you believe that federal employees, staff, even members of Congress should attempt guidance on the issue of the use of personal emails versus some official form of communication? What should we learn from the process the Secretary has gone through? I'm sure there will be questions about how there was even confusion, for example, in the State Department. But what should we learn when it comes to our own use of email or the use of federal employees on this question?
May I answer, Mr. Chairman? The most important thing to learn is that an unclassified email system is no case for an email conversation about classified matters. And by that I mean either sending a document as an attachment over unclassified email that is classified, or having a conversation about something that is a classified subject on an unclassified email system. That's the focus of the concern, that's the focus of this investigation. That it was also a personal email adds to the concern about the case because of the security vulnerabilities associated with a personal system. But the root of the problem is people using unclassified systems to conduct business that is classified. And so all of us should have access to, if we have access to classified information, classified communication systems. The FBI has 3 levels: unclassified system, a secret system, and a top secret system. You can email on all 3, but you need to make sure you don't email on the unclass system, even if that's a government classified system, about matters that are classified. That's the important lesson to learn. Everybody ought to be aware of it. Everybody ought to be trained on it. We spend a lot of time training on it in the FBI to make sure folks are sensitive to the need to move a classified discussion, even if it doesn't involve sending a document, to the appropriate forum.
Members of Congress included.
Of course.
Thank you, Mr. Chairman.
We'll now recognize the gentleman from Florida, Mr. DeSantis, for 5 minutes.
Director, and the reason why that's so important is because if top secret information is compromised, that could damage our national security, correct?
Yes, by definition.
And American lives are at stake in some instances, correct?
Yes.
You mentioned a lot of people are upset that there are no consequences for Secretary Clinton, but in your statement you did point out that administrative and security consequences would be appropriate if someone demonstrated extreme carelessness for classified information. So those consequences, that would include potentially termination of federal employment?
Correct.
It could include revocation of security clearance?
Yes.
And it could include ineligibility for future employment in national security positions, correct?
It could.
Now, would you, as the FBI director, allow someone in the employ of your agency to work in a national security capacity if that person had demonstrated extreme carelessness in handling top secret info?
The best answer to that is we would look very closely at that in a suitability determination. It's hard to answer in the abstract, yes in all cases, no in all cases, but it would be a very important suitability scrub.
So there would be instances where someone could be extremely careless but still maintain confidence. We have a lot of people who are very competent in this country who would love to work for your agency, but yet it would be potentially you would allow somebody to be extremely careless and continue on?
That's the trouble with answering the hypothetical. I can imagine if it was a long time ago and it was a small amount of conduct or something, that's why it's hard to say, other than It would be a very important part of
Let's
the
just put it this way. Would being extremely careless in handling top secret information expose an employee of the FBI to potential termination?
Yes.
Why shouldn't U.S. officials use mobile devices when traveling to foreign countries, especially if they're discussing classified or sensitive information?
Because the mobile device will transmit its signal across networks that are likely controlled or at least accessed by that hostile power.
And that's the guidance that the FBI gives all officials when they're traveling overseas. That's still good guidance, correct?
That's good guidance.
How did top secret information end up on the private server? Because your statement addressed Secretary Clinton. You did not address any of her aides in your statement. Attorney General Lynch exonerated everybody. That information just didn't get there on its own. So how did it get there? Were you able to determine that?
Yes, by people talking about a top secret subject in an email communication.
So it was
It's not about forwarding a top secret document. It's about having a conversation about a matter that is top secret.
and those were things that were originated by Secretary Clinton's aides and then sent to her, which was obviously being her server, but it was also included Secretary Clinton originating those emails, correct?
That's correct. In most circumstances, it initiated with aides starting a conversation. In the one involving top secret information, Secretary Clinton, though, also not only received but also sent emails that talked about the same subject.
And of that top secret information that you found, would somebody who was sophisticated in those matters, should it have been obvious to them that that was very sensitive information?
Yes.
So I guess my issue about knowledge of what you're doing is, in order for Secretary Clinton to have access to top secret SCI information, didn't she have to sign a form with the State Department acknowledging her duties and responsibilities under the law to safeguard this information?
Yes. Anybody who gets access to SCI, sensitive compartmented information, would sign what's called a read-in form that lays that out. I'm sure members of Congress have seen the same thing.
And it stresses in that document, and other training people would get, that there are certain requirements to handling certain levels of information. For example, a top secret document, that can't even be on your secret system at the FBI, correct?
Correct.
So you have to follow certain guidelines. And I guess my question is she's a very sophisticated person. She did execute that document, correct?
Yes.
And her aides who were getting the classified information, they executed similar documents to get a security clearance, correct?
I believe so.
And she knowingly, clearly set up her own private server in order to, well, actually, let me ask you that. Was the reason she set up her own private server, in your judgment, because she wanted to shield communications from Congress and from the public?
I can't say that. Our best information is she set it up as a matter of convenience. It was an already existing system that her husband had, and she decided to have a domain on that system.
So the question is very sophisticated. This is information that clearly anybody who had knowledge of security information would know that it would be classified. But I'm having a little bit trouble to see, how would you not then know that that was something that was inappropriate to do?
Well, I just want to take one of your assumptions about sophistication. I don't think that our investigation established that she was actually particularly sophisticated with respect to classified information and the levels and the treatment. And so far as we can tell...
Isn't she an original classification authority, though?
Yes, sir. Yes, sir.
Good grief. Well, I appreciate you coming, and I yield back the balance of my time.
I thank the gentleman. I ask unanimous consent to enter into the record two documents that Mr. DeSantis referred to. One is the sensitive compartmented information non-disclosure agreement. The other one is the classified information non-disclosure agreement, both signed by Hillary Rodham Clinton. Without objection, so ordered. Now recognize the gentleman from Missouri, Mr. Clay, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Director Comey, for being here today, and for the professionals whom you lead at the FBI. 2 years ago, after my urgent request to then former Attorney General Eric Holder for an expedited Justice Department investigation into the tragic death of Michael Brown in Ferguson, Missouri, I witnessed firsthand the diligence, professionalism, and absolute integrity of your investigators. And I have no doubt that was the case in this matter as well. I did not think it was possible for the majority to exceed their unprecedented, arrogant abuse of official channels and federal funds that we have witnessed over the past 2 years as they have engaged in a partisan political witch hunt at taxpayer expense against Secretary Clinton. But I was wrong. This proceeding is just a sequel to that very bad act, and the taxpayers will get the bill. It's a new low, and it violates both House rules and the rules of this committee. So with apologies to you and the FBI for this blatantly partisan proceeding, let me return to the facts of this case as you have clearly outlined them. First question. Did Secretary Clinton or any member of her staff intentionally violate federal law?
We did not develop clear evidence of that.
Did Secretary Clinton or any member of her staff attempt to obstruct your investigation?
We did not develop evidence of that.
In your opinion, do the mistakes Secretary Clinton has already apologized for and expressed regret for rise to a level that would be worthy of federal prosecution?
As I said Tuesday, our judgment, not just mine, but the team's judgment at the FBI, is that the Justice Department would not bring such a case. No Justice Department, under any, whether Republican or Democrat administration.
Thank you for that response. I know the FBI pays particular attention to groups by training agents and local law enforcement officers and participating in local hate crime working groups. Is that right?
Yes, sir.
Some of these organizations seem relatively harmless, but others appear to be very dangerous and growing. Some even promote genocide in their postings and rhetoric online. In your experience, how dangerous are these groups, and have they incited violence in the past?
I think too hard to answer, Congressman, in the abstract. There are some groups that are dangerous. There are some groups that are exercising important protected speech under the First Amendment.
Okay, let me ask about a more direct question. A gentleman named Andrew Anglin is the editor of a website called The Daily Stormer that is dedicated to the supremacy of the white race as well as attacking Jews, Muslims, and others. The website features numerous posts with the hashtag white genocide to protest what they contend is an effort to eliminate the white race. Are you familiar with this movement?
I'm not.
Okay. Well, this hashtag has been promoted all over social media by a growing number of white supremacists. For example, one Nazi sympathizer tweeted repeatedly using the handle @WhiteGenocideTM. Are you concerned that some groups are increasing their followers in this way, particularly if some of those followers could become violent?
I don't know the particular enough to comment, Congressman. We are always concerned when people go beyond protected speech, which we do not investigate, to moving towards acts of violence. And so our duty is to figure out when have people walked outside the First Amendment protection and are looking to kill folks or hurt folks. But I don't know enough to comment on the particular.
I see. Well, one of my biggest concerns is that certain public figures are actually promoting these dangerous groups even further. And as you may know, one of our most vocal candidates for president retweeted @WhiteGenocideTM. 3 weeks later, he did it again. 2 days after that, he retweeted a different user whose image also included the term white genocide, and that's not even all of them. Director Comey, don't these actions make it easier for these racist groups to recruit even more supporters?
I don't think I'm in a position to answer that in an intelligent way sitting here.
Well, I appreciate you trying, and thank you, Mr. Director, for your exceptional and principled service to our country. I yield back.
Thank you. We'll now recognize the gentlewoman from Wyoming, Ms. Lummis, for 5 minutes.
Welcome, Director, and thank you so much for being here. My phone has been ringing off the hook in my Washington office and my Wyoming office from constituents who don't understand how this conclusion was reached. So I appreciate your being here to help walk us through it. And here's the issue that the people that are calling me from Wyoming are having. They have access to this statute. It's Title 18, U.S. Code 1924, and I'm going to read you this statute. It says, whoever being an officer, employee, contractor, or consultant to the United States, and by virtue of his office, employment, position, or contract, becomes possessed of documents or materials containing classified information of the United States, knowingly removes such documents or materials without authority and with the intent to retain such documents or materials at an unauthorized location, shall be fined under this title or imprisoned for not more than 1 year or both. Armed with that information, they're wondering how Hillary Clinton, who is also an attorney, and attorneys are frequently held to a higher standard of knowledge of the law, how this could not have come to her attention. She was the Secretary of State. Of course the Secretary of State is going to become possessed of classified materials. Of course she was attorney. She practiced with a prominent Arkansas law firm, the Rose Law Firm. She knew from her White House days with her husband, the president, the classified materials can be very dangerous if they get into the wrong hands. She had to have known about this statute because she had to have been briefed when she took over the job as the Secretary of State. So how, given that body of knowledge and experience, could this have happened in a way that could have potentially provided access by hackers to confidential information?
No, it's a good question, a reasonable question. The protection we have as Americans is that the government, in general and in that statute in particular, has to prove before they can prosecute any of us that we did this thing that's forbidden by the law, and then when we did it, we knew we were doing something that was unlawful. We don't have to know the code number, but that we knew we were doing something that was unlawful. That's the protection we have, and it's one I've worked for very hard. When I was in the private sector, I did a lot of work with the Chamber of Commerce to stop the criminalization of negligence in the United States.
You know, though, may I interrupt and suggest that this statute says knowingly remove such documents or materials without authority and with the intent to retain such documents or materials at an unauthorized location. The intent here in the statute is to retain the documents at an unauthorized location. It's not intent to pass them on to a terrorist or to someone out in internet land. It's just the intent to retain the documents or materials at an unauthorized location.
Yeah, it's more than that, though. You'd have to show that and prove criminal intent, both by law, that's the way the judge would instruct a jury, and